Okay, so for this episode, our topic is the liberty of abode still in the Bill of Rights. So this is the section 6 of the Bill of Rights, which says that the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health as may be provided by law. It includes the right to choose one's resident and to change the same. But there are limitations. Within the limits may be prescribed by law, and number two, it may be impaired by the lawful order of the court. So, the law can only prescribe limitations to the liberty of abode. It cannot impair it. The right to travel or the freedom of movement. It refers to the right to move from one place to another. In the Bill of Rights, it covers the right to travel from the Philippines to another country and the right to travel within the Philippines. So, pwede tayong mag-ibang bansa or pumasyal sa sarili nating bansa. But the limitations is that it can be impaired in the interest of the national security, public safety, or public health as may be provided by law. It can be impaired by a lawful order of the court. So, for example, during pandemic, lockdown, pinagbawalan ang mga tao na lumabas sa kanilang mga bahay. Can it be considered as a violation of our freedom to the liberty of abode? The answer is no, because it states that the limitation is that it can be impaired in the interest of the national security, public safety, or public health. Here in the present example, in public health, would be transfer of virus, diba? So, unlike in the liberty of abode, the right to travel may be impaired by law in the interest of national safety, public safety, or public health. It does not cover the right to return to the Philippines from another country. This third right is merely protected by international law. Ayan. In the case of International Covenant on Civil and Political Rights, provides that no one shall be arbitrarily deprived of the right to enter his own country. Hence, as long as the deprivation is not arbitrary, the right to return to the Philippines can be impaired. Law. So, it shall be restricted to statutes or legislative enactments, as stated in Genuino versus De Lima, 2018. However, Leonen disagrees with these rulings in his opinion that law must extend to the Constitution, executive acts, and administrative orders. Si Justice Leonen daw ay nagdi-disagree. Instances where a law impaired the right to travel in the interest of the national security, public safety, and public health, the Human Security Act, National Security, the Philippine Passport Act of 1996 for public safety, Anti-Trafficking in Persons Act, the public safety, Migrant Workers and Overseas Filipinos Act for public safety, the Curfew Ordinance on Minors promote juvenile safety and prevention of juvenile crime. Hence, the ordinance can impair the right to travel of minors. So, doesn't this violate the term law? No, because the power of the LGU to impose curfew or ordinances was delegated by Presidential Decree 03, which is a law. Number 2, watch list and HDO right to travel. When the right to travel may be impaired by order of the court. So, precautionary hold departure orders. It is issued by the court with an ex parte petition involving crimes where the minimum penalty is 6 years and 1 day was filed. It can be applied for in court even if the case is still pending. Preliminary investigation. So, in Inwino versus Secretary De Lima, the Supreme Court declared DOJ Circular Number 41 authorizing the Secretary of Justice to issue whole departure orders or HDOs, watch list orders or WLOs, and allow department orders unconstitutional as it violates the right to travel. Under the Constitution, for the right to travel to be impaired in the interest of national security, public safety, or public health, there must be a law. Okay? An act of Congress. Pag sinabing law, is an act of Congress. Hindi pwedeng ordinance lang. A mere administrative relation or circular is not a law. On the other hand, the court can validly issue watch list orders or HDO. So again, yung limitations lang natin for the liberty of abode is that when the limits may be prescribed by law. So kapag ang tinanong, there was an ordinance passed, there was a resolution passed by the city of Manila, by the city of ganito, does it violate the liberty of the our right to liberty of abode, or does it violate section 6 of the Bill of Rights? Yes, it does, kasi it's not a law. Okay. Okay, so yung first limitation is prescribed by law, and yung second limitation is that it may be impaired by the lawful order of the court. So if the court issued a watch list order, a whole departure order, then it's just and proper. Okay? So thank you so much for joining me in my review session on the liberty of abode.